started. Good afternoon, everyone. I'm Linda Ross from the Construction and Projects team at Burness Paull. I am joined today by my colleagues Gavin Payton and Karen Manning. A warm welcome to the first of 3 webinars in our construction webinar series. The focus of this session is going to be on contract drafting and negotiation in the context of COVID-19. But our webinar next week, on the 4th of November, will cover developments in adjudication, and our final session on the 12th of November will look at what we think is the top 5 cases, gosh, I was nearly committing us to 20 cases, the top 5 cases of 2020. If you'd like to sign up, we will be putting some details in the chat function. So while we're just waiting for the last few people to join us, let's do some housekeeping matters. Please keep that infamous mute button on. We automatically muted you when you came and joined the call, but if you could just be sure to keep yourself muted, that would be great. Also, please feel free to ask questions via the WebEx chat function. Now, you can either direct your questions to me, or if you're comfortable, post them to everybody. We'll address the questions at the end of the session, and I will anonymise any generic questions so that we can record the webinar and distribute it afterwards. We are aiming to speak today for no more than 45 minutes, and we'll have questions at the end. But one thing to point out is we won't be using slides today. We're going to do a debate format. So can I recommend that you set your view to active speaker view? And if, like me, you're not entirely sure how to do that, then you go to the top right-hand corner of your screen, and there is an active speaker button, which will just allow Gavin, Karen, or myself to pop up when we are chatting. So I do recommend that view, as it will make, hopefully, it a bit easy to follow the presentation. We will be recording today's session, and the recording will be sent to you all afterwards. So I think we should just get started. With the US presidential election reaching a crescendo, it seemed appropriate to adopt a Trump-Biden style debate format for this session. So in the blue corner, we have Gavin, Make Construction Great Again Payton, wearing his building contractor hat. Maybe you could give us a wave, Gavin. There we go. And in the red corner, we have Karen Manning, Battle for the Soul of Construction. She's going to be wearing her employer hat. I'm going to act as the referee and introduce each of the topics, which will be debated between Gavin and Karen. So there is a bit of a warning I have to give at the beginning here. In pulling on the contractor and employer jerseys respectively, I have asked Gavin and Karen to represent the arguments they see being made and the positions they are seeing in the market. But it does have to be said that some of the points they're going to be representing today have more weight than others. I'm sure you'll form that view yourself. But we thought it would be helpful to share all of the angles that we are seeing being taken in the market. Now, my job is to set the scene. So I'm going to do that hopefully quite quickly. I'd like you to cast your minds back to March, when the Scottish Government issued the Health Protection Coronavirus Restrictions Scotland Regulations 2020. Now, there's a snappy title if ever there was one. And at the same time, they issued government guidance. And there was a large gulf. There was a large gulf between the requirements of the regulations on the one hand and the requirements of the government guidance on the other. While the mandatory regulations did not require the closure of any construction sites, the non-mandatory guidance was explicit in its direction that construction sites for non-essential projects should close. Now, some contractors found it difficult to get all risks insurance cover, and the hysteria, and don't use that word lightly, in the media then arose whenever a contractor tried to resume construction activities as the law permitted. This meant that for reputational reasons, most contractors concluded that they should comply with the Scottish Government's non-mandatory guidance to close non-essential sites. As well as reputations being at stake, contractors had the HSE in the background saying they could intervene and would intervene where they considered it appropriate to do so. And there were cases of the police visiting construction sites urging them to close, notwithstanding the absence of any clear legislative requirement for that happen. So ultimately, a large number of contractors concluded that it was health and safety issues associated with the guidance that there was a direct cause of them requiring to close their sites. More recently, following the general closure of sites, we've had this gradual phased return to construction activity with the soft start from 15th June moving through to steady state progress, which permits construction with social distancing and the use of PPE. Moving forward, who knows what's going to happen? The recent debate around the need for circuit breaks leads to the possibility that new restrictions may be imposed, and these may involve the closure of sites. So that's the scene set. Our objective today is to consider the position in respect of contracts that existed prior to lockdown. And secondly, look at the commercial landscape as it is actually now and what we are seeing as we're advising clients. We'll look at those issues in the context of SBCC and NEC. So just a little reminder, set your screen to active speaker video view, and we will now move to hear Gavin and Karen. Can I say, guys, I want a clean fight. I want you to protect yourselves at all times, even if your personal view is the argument that you are making is somewhat paper thin. So, round one, pre-lockdown contracts, extensions of time and loss and expense. This is the round where we'll be focusing on contracts entered into pre-lockdown and how contractors are formulating their claims relating to extension of time, and indeed how employers are seeking to resist them if they are inclined to do so. Gavin, what bases are you seeing contractors using to claim for EOTs as a consequence of COVID? And how do you think employers might seek to resist those claims if inclined to do so? Over to you, Gavin.
Well, thanks, Linda. Firstly, I'd like to focus on the SBCC and JCT forms of contract. And I think the best way to approach this is firstly to consider the period when non-essential construction sites were generally closed in Scotland. And in respect of that site closure period, there are, as I see it, 4 potential bases of entitlement. So Karen and I will consider each of those in turn. The first ground, based on SBCC and JCT, is where the employer or contract administrator takes control and issues an instruction to the contractor to postpone work on site. In that scenario, it seems very clear that the contractor will be entitled to an extension of time. However, in my experience, in many cases, employers didn't issue instructions and were largely content to leave the contractor to decide whether or not to continue on site.
Thank you for such an easy one to begin with, Gavin. I completely agree.
Great. Well, let's move swiftly on then. In ground 2, or the second ground for claiming an extension of time under SBCC JCT contracts, I've seen some contractors argue that an employer default or act of prevention relevant event has occurred. And by way of example, a contractor might point to Regulation 4 of the CDM regulations that imposes on the employer an obligation to make suitable arrangements for the management of the project. Those employer arrangements are only suitable if they ensure that the construction work can be carried out so far as reasonably practicable without risks to the health and safety of any person affected by the project. Some contractors are using this as a basis for suggesting that because Scottish Government guidance was that non-essential construction sites should close, it was incumbent on the employer to issue an instruction postponing or suspending the works to comply with Regulation 4 of the CDM regulations and to ensure the health and safety of the contractor's workforce and others on site. And they claimed that that failure to issue that instruction was a default or active prevention entitling the contractor to claim an extension of time. I have to say that even with my contractor hat on, I do find that quite a challenging argument.
Yeah, I've got lots to say about that, Gavin. Any contractor, in my opinion, is definitely on a sticky wicket with this one. I mean, issuing an instruction to postpone under the contract is entirely up to the employer. Without statutory regulations making site closures mandatory, I think an employer would have a seriously good rebuttal to this argument if they have acted as a responsible employer throughout the project. There is lots to say on this, but the key point I would probably make is the requirement that you appear to be hanging your hat on is only so far as is reasonably practicable. So it's not absolute, and a responsible employer should be able to satisfy it in COVID circumstances.
Well, thanks, Karen. And feeling suitably pummeled with that response, I'll move on to the third potential ground put forward by some contractors for claiming extension of time under SPCC JCT contracts. And that's relying on the relevant event relating to the exercise of statutory powers by the Scottish Government. As Linda pointed out in her introduction, the site closure requirements imposed on the construction sector were imposed through Scottish Government guidance and not statutory powers. So again, even with my contractor hat on, I think we have to accept that that ground of entitlement to an extension of time is not available.
Yeah, and I would agree. Another easy one for me. The employer is in a pretty strong position here.
Moving on then to the final ground for a contractor claiming an extension of time under SPCC JCT contracts, I'd like to touch on force majeure relevant event. Assuming that the employer didn't issue an instruction closing the site, then I think that a force majeure relevant event-based argument is often the most robust one that a contractor will have. Unlike some other contracts, the SPCC JCT forms don't define force majeure, and I accept that the meaning of that term is open to some legal debate. However, for the contractor, I'd maintain that the term force majeure is used to define any circumstances not otherwise described as a relevant event that's out with the reasonable control of the contractor, i.e. force majeure is that bucket for other events out with the contractor's control that the parties didn't specifically think about or identify when they entered into the contract. I think that a contractor can argue quite forcefully that the pandemic, associated health and safety requirements, and the Scottish Government guidance are circumstances out with its reasonable control and as a consequence, a force majeure relevant event.
Well, I do agree with you, Gavin, that rather unhelpfully there is a lot of uncertainty around the meaning of force majeure, and it is likely to be defined with reference to the contractor's reasonable control. But I don't accept that your proposal then means that force majeure is this bucket for all other events out with the contractor's control. I would argue that there are a number of other relevant events listed in the SPCC JCT contract, which are force majeure type events, and therefore the catch-all reference to force majeure at the end of this list should be interpreted as circumstances that can't be expressly defined, but that are closely aligned to the other defined force majeure type events already listed. It's also probably worth mentioning that perhaps for many of the reasons we've mentioned, in negotiations, force majeure is often deleted from the relevant events entitling a contractor to time under SPCC and JCT contracts, and so it might not even offer a possible solution to some contractors. And I would also argue for an employer that a contractor can't be entitled to an extension of time for force majeure when that force majeure is something that was foreseeable by the contractor when entering into the contract. And even with contracts entered into in the months before lockdown, if you considered the impact COVID was having on other countries around the world, it could be reasonably foreseeable that COVID-related events could delay projects in the UK.
Well, I think I'd like to counter that foreseeability argument, Karen. Under the SPCC JCT contracts, the term force majeure, as we know, is undefined. It's not qualified by any express foreseeability test. I would argue for a contractor that the foreseeability or otherwise of the event is irrelevant for the purposes of ascertaining whether it falls within force majeure. The sole relevant question It's whether the event is out with the reasonable control of the contractor.
Okay, thanks both. I don't think we're going to get you to agree there on the foreseeability issue. So let's move on. Up until this point, we've looked at the period during which construction sites were closed in Scotland. So now I'm going to ask you about the period from mid-June when sites began to open. What is the basis for contractors claiming an extension of time under SPCC contracts in that period from mid-June up until the present day? What do you think?
Okay, thanks, Linda. Well, for the period after the end of site closure, as you say, from mid-June onwards, the position for the contractor is that they may be able to rely on the exercise of statutory powers relevant event, on the basis that the statutory regulations introduced in mid-April expressly required that social distancing criteria be adhered to, and that could be relied upon to secure an extension of time for delays that are attributable to compliance with those social distancing requirements. However, the impact of social distancing requirements on the progress of the works will be more difficult to prove when compared with the relatively black and white impact of a site closure. The causative links between the Scottish Government guidance, the site closure, and the delay flowing from it are likely to be relatively clear. The position is less clear-cut when it comes to establishing social distancing requirements and whether they've extended the period for completion. And the contractor does need to think carefully about the paper trail required to support an entitlement to extension of time in those circumstances.
Yeah, in my opinion, I think the employer is in a fairly strong position from mid-June onwards in relation to extension of time claims, although the statutory powers ground is probably one which the contractor can hang their hat on. As Gavin has already touched on, I think as establishing that an event falls within the ground, a causative link has to be established between period of delay and the related event, and that is likely to be far more difficult to prove in social distancing circumstances.
Okay, thanks both. So at the moment, we've been looking at their SPCC extensions of time. Can we move on now and look at claims for loss and expense? Again, in the context of SPCC JCT. So starting with Gavin again, are contractors also making claims for loss and expense? And if so, how are they going about it, Gavin?
Well, in relation to loss and expense, any entitlement to rely on grounds would have to be a relevant matter as defined in the SPCC and JCT contracts. And I have to accept that neither force majeure nor compliance with statutory requirements are relevant matters under the SPCC JCT contracts. So loss and expense is not really a feature available to the contractor to pursue. Tactically, however, acting for a contractor who is looking to recover loss and expense, I'd be looking for conduct on the part of the employer that the contractor could argue was a default or active prevention relevant matter.
Well, I Gavin, would probably counter that, and well, I would agree firstly that I think it's extremely difficult for a contractor to make a claim for loss and expense under the relevant matters other than by way of default or active prevention. But for the reasons already mentioned in relation to time, I think that would be a very difficult argument to run for any contractor. So I think the position from an employer's perspective is fairly safe under SPCC JCT in relation to loss and expense.
Good. Right, let's put SPCC JCT contracts to the side for a moment and move on to consider NEC-based contracts. So we'll do a similar sort of split. We will look at contracts entered into pre-lockdown. What are you seeing in relation to claims for extensions of time? So focus on NEC.
Okay, well, under an unamended NEC contract, the contractor's entitlement to extension of time and additional payment will flow from the occurrence of a compensation event, which prevents the contractor completing the works in accordance with the accepted programme, and which neither party could prevent, and which an experienced contractor would have judged when entering into the contract to have such a small chance of occurring that it would have been unreasonable for him to have allowed for it. This brings in a foreseeability test when it comes to determining whether there is a compensation event. In respect of contracts entered into prior to March this year, I'd maintain for the contractor that the risk of site closure because of the outbreak of a pandemic should be regarded as being an event having such a small chance of occurring that it would have been unreasonable for the contractor to allow for it?
I would say, Gavin, that a contractor might actually struggle in meeting the foreseeability test for claiming relief for COVID-related events, even down. If we cast our minds back to prior to March, the outbreak and spread of the virus was something that was happening in other parts of the world, and it was having a catastrophic effect. I would argue that at least in the months running up to March, it was entirely predictable that the effects seen in China, in Italy, in France, and in Spain would be replicated in the UK. The words global pandemic were commonplace in the news, and a UK contractor should have considered these risks and the consequences on cost and programme in any contract that they were entering into.
Well, Karen, I think it can be argued that it would be very harsh to hold any contractor to account for failing to allow for the consequences of COVID-19 as it was experienced in other jurisdictions. Certainly my recollection at the time of the outbreak of the pandemic in the UK was that we were being told by our politicians that it was not a foregone conclusion that we would suffer in the same way as other countries, and that we were well prepared as a country to prevent the adverse consequences we were seeing in those other countries. I think it can be argued that contractors cannot reasonably be criticised for relying on those assurances, and it's appropriate for the contractor to proceed on the basis that a compensation event has occurred.
Okay, so I see that you're still at loggerheads over the issue of foreseeability. Let's move on to stick with NEC, but let's move on and consider loss and expense type claims. Just a few quick words about that.
Well, one major distinction between the NEC suite and the SBCC JCT suite is that all compensation events under NEC entitle the contractor to an increase in the prices, as well as an extension of time. And if more money is at stake, there may be greater scope for disputes to emerge when it comes to the application of the foreseeability test. The entitlement to an increase in the prices will arise where we're dealing with an unamended NEC contract. Often, though, the unforeseeable event compensation events in NEC are deleted in their entirety, or sometimes replaced with more specifically defined events. Also, we often find that NEC contracts are amended to ensure that the contractor's entitlement in respect of neutral force majeure type events is limited to extension of time only, i.e. the entitlement to an increase in prices is removed.
Yeah, and I would agree, Gavin. The employer is definitely not in as good a position in relation to money claims under at least an unamended NEC as they would be under SBCC or JCT.
And are there any other compensation events that you think might be relevant that we've not discussed so far?
Well, if the X2 option under NEC selected a change in law in the country of the site occurring after the contract date, well, that is a compensation event. So if there are new statutory regulations imposed after the contract date in the UK, and those expressly require the sites to be closed, then the contractor could rely on that compensation event.
Okay, so thanks both of you. Up until this point, we've been very lawyerly and we've been considering the contractual positions being adopted by contractors and employers. But we all know from experience that parties do not always take a strict contractual position. And sometimes they can try to agree a way forward when there's a bump in the road. So my question to you now is, are you seeing a degree of pragmatism being taken by contractors and employers, regardless of the strict contractual position?
Well, maybe I'll pick up on that one, Linda. I mean, there seems to have been little appetite for conflict in these issues, certainly so far. To date, all I've really witnessed is contractors issuing the notices that they're required to issue to protect their contractual positions. In most cases, the notices issued on behalf of contractors under SBCC and JCT contracts focus on the force majeure and exercise of statutory power grounds. They haven't generally sought to give notice of employer acts of default or prevention, which can be relied upon to claim loss and expense in addition to extension of time. With regard to NEC contracts, there may potentially be less need for contractors to resort to what might be seen as inflammatory arguments relying on employer acts of default or prevention. given that time and money is available for all compensation events, including the unforeseeable events compensation event, assuming, of course, that the NEC contract has not been amended. My experience so far has been that provided that the debate is limited to one that is about extension of time, rather than loss and expense, employers have generally been prepared to entertain an entitlement to an extension of time, at least to some extent.
Good. So up until now, we've been considering the position and contracts entered into prior to lockdown. But what are you seeing in terms of current market practice? So what I'm talking about here is contracts being entered into at this point in time when we are, I suppose, mid-pandemic. How is COVID related delay and additional cost risk being allocated in the contracts which are being entered into right now?
Well, Linda, it is definitely on everybody's radar. We are seeing huge amounts of discussion and negotiation on this topic and plenty of bespoke drafting. I would say there's definitely a recognition that the outbreak and the spread of the virus as an event should be dealt with in its own right, as an event in its own right, rather than as part of the SBCC force majeure or the NEC unforeseeable events. Some example drafting has emerged by industry bodies. Construction Leadership Council is a good example of some example drafting which is available online. But I would say there's no standard approach really. There are maybe some themes, maybe 4 or so themes that surround the negotiations. The first is probably about status quo. Clauses are generally concerned with changes from the status quo, and that position generally seems to be accepted by both employers and contractors at the point of signing the contract. There's concern about mutations, which might lead to future outbreaks being categorised as something different to COVID, and as well as the natural consequences and effects attributable to the outbreak of the virus. COVID events should also cover any changes in the statutory regulations that we've mentioned and the relevant related guidance. Contractors especially are looking for the entitlement to include for the consequence of shortages of labour and materials as you might expect. I would also say that for the time being, it does seem that the majority of the debates on relevant drafting relate to time rather than money, which is kind of consistent with Gavin's points. In my experience, employers, are not being asked to grant relief for loss and expense, really, and contractors seem generally resigned to the fact that no loss and expense will be payable in these circumstances.
Okay, thanks to both of you. That brings to a conclusion the round 1. We're going to move on now to round 2, which is termination. So here's my question for you both. Anecdotally, I understand that some contractors have sought to rely on the termination provisions in their SBCC JCT-based contracts, and I would be very interested to hear your views on that tactic. What do you think?
Well, Linda, the provision being relied on here is the mutual right of termination that's available under the SBCC JCT contracts, where the whole or substantially the whole of the works are suspended for a specified period because of a force majeure type event or other prescribed circumstances. The period of suspension, after which termination rights are available, can be specified in the contract particulars. However, if nothing is specified, the default period is 2 months. Even where force majeure as a relevant event has been amended or deleted, it's relatively unusual to find the force majeure termination rights also being amended. So the mutual right to terminate because of suspension of the works as a consequence of force majeure is generally remained available. I have seen some evidence of contractors relying on these rights, and during the period of site closure, some employers were quite concerned about the possibility of contractors exercising the right to terminate. However, perhaps the real concern of the employers was more about the threat of termination by the contractor, who may have been tempted to use that threat of termination as a bargaining chip to secure an extension of time and possibly some recovery of the contractor's additional costs arising out of site closure.
I mean, I agree with you, Gavin, that it is unusual to ever see the force majeure event deleted in the mutual termination clause. And I wonder if that's actually because some parties don't realise it's there. Anyway, it looks like we were back to deciphering what might constitute force majeure, undefined, and trigger either party's right to terminate. I think it's worth remembering that this is a mutual termination clause, so it could work for the benefit of both the contractor and the employer. And that's perhaps why it is rarely amended. But in our experience, this clause is generally viewed as favourable, much more favourable to the contractor, as it's the contractor that is far more likely to terminate than the employer in a suspension scenario. And if the contractor does exercise that right, that leaves the employer in a really challenging position with a partially completed project, delay issues, having to re-tender, and the related additional cost exposure. I suppose, like the relevant events clause, the mutual right to terminate includes a number of other force majeure type events, and they are expressly defined. So for the reasons I've already mentioned in relation to time, I would suggest that these other listed events help the employer argue that a pandemic type event should not fall within force majeure small f small m. And because that is because a pandemic event is not closely aligned with the other events specified, and the force majeure trigger should not act as, to use Gavin's word, bucket to catch everything else that the parties could not think of at the time that the contract was entered into. Because otherwise, there would be no need to list any of the events specified, really, would there?
Okay, then just a few quick words. What's the position on termination rights under the NEC contracts in the context of COVID-19?
Okay, yeah, there is a termination event available in NEC contracts where an unforeseeable event delays completion by a period of more than 13 weeks in this case. But under NEC, only the employer is entitled to terminate the contract in those circumstances. So the potential termination threat lever that we referred to that's available under SBCC and JCT contracts, where force majeure suspend the works, is not a lever that's available to contractors under NEC contracts.
Yeah, as you've said, that there's no lever for a contractor to pull on via the termination provisions under NEC. It's an employer's right only, so I don't think there's much more to say on that.
Okay, so moving on now to contracts entered into mid-pandemic at this point in time. What are you seeing? Are you seeing contractors or employers trying to amend the termination provisions?
I suppose in relation to NEC, we haven't so far seen any great evidence to suggest that there's a desire to tinker with the termination provisions under the NEC form of contract. However, it's quite different in relation to SBCC and JCT. And I've seen quite a lot of circumstances already where the SBCC JCT termination provisions have been amended to account for COVID. And that suggests that the parties are now aware of the force majeure trigger here, the uncertainties around it, and they also may be seeing the contractor's threat of termination as a risk. I suppose in terms of thinking about the amendments, the types of thing we have seen are that the default suspension period is extended to build in additional suspension time before the right is triggered, and also that a COVID-specific relief event is excluded right to terminate. But I've also seen force majeure being deleted and a COVID-specific relief event being included in its place. So parties are taking different approaches to the risk here. It's also probably worth mentioning that in a lot of the SBCC and JCT contracts that we deal with, the parties do agree to delete the mutual right to terminate altogether. I think some contractors can get themselves comfortable on this because it's not market standard to have a mutual right to terminate. I mean, the NEC is a good example where the right exists for the employer only, and it's also only relevant to a suspension scenario. So the contractor is not on site incurring further costs in these sorts of circumstances. In my experience, it's often the preference of the employer not to be exposed to the risk of being left without a contractor on a half-finished project, where works are suspended for force majeure type circumstances, and they generally expect the contractors to be committed to the project as they are.
Right, thank you. That brings to an end round 2. We've now got 2 very short rounds just to do to take us to the end of the webinar. Round 3 is increases in the cost of labour, materials and plant. So here's my question to you. One potential impact of the COVID-19 is increases in the cost of labour, materials and plant. So firstly, in the context of SBCC, JCT contracts, does the employer or the contractor carry the risk of these cost increases?
Well, Linda, in short, I think it's difficult for a contractor to establish a basis for claiming such increased costs under a standard SBCC JCT contract, even if the standard form fluctuation provisions are applied, which in our experience is unusual. They wouldn't cover cost increases that arise out of the impact of COVID-19. However, if the contractor could establish a COVID-19 related relevant matter, allowing a claim for loss and expense, such as employer default or active prevention, then it might be contended that the increased costs of labour, materials and plant is, in certain circumstances, a consequence of the delay or disruption attributable to the COVID-19 relevant matter.
Okay, and how about the same question in relation to NEC contracts?
Well, in NEC contracts, the contractor's financial entitlement in respect of any compensation event is ascertained by establishing the effect of the compensation event on the actual defined cost of the work already done and the forecast defined cost of the work still to be completed. So, if one of the effects of a COVID-19 related compensation event under NEC is to generate inflationary pressures, increasing the cost of labour, materials and plant, then such costs would form part of the contractor's entitlement to compensation. In NEC contracts then, I think the contractor is in a better position to potentially claim cost increases affecting labour, materials and plant.
Okay, and so my last question in this round is bringing it back to contracts which we're entering into just now. Are you seeing contracts being specifically amended to deal with COVID-19 related increases in cost?
Well, I have seen some instances of this as part of a menu of changes that some contractors have sought to include in building contracts being entered into mid-pandemic. Given the relatively recent ongoing actually anxieties of contractors around the impact of Brexit on the price of labour, materials and plant, I've actually been quite surprised that more contractors have not been raising the issue of inflation arising out of COVID-19, given that it's an issue that has been very alive recently.
Okay then. Thank you. So that brings to an end round 3, and our last round is round 4, which is acceleration agreements. So my question is, as we all know, a significant number of projects have been delayed as a consequence of the impact of COVID-19. So Gavin and Karen, are you seeing acceleration agreements being used to get projects back on programme, or at least to recover some lost time? And if so, what do you find employers and contractors are looking for in these acceleration agreements?
In short, in answer to your question, Linda, yes, particularly for time critical works like student accommodation projects, for example, where it's imperative that the facility is open for the start of the academic year. And we've seen quite a few parties agree to accelerate the works to try to make up for time during COVID. It's worth noting that a number of the standard form building contracts do have express terms addressing potential acceleration, and that includes the forms we're covering today, SBCC and JCT, as well as NEC4 in the engineering construction contract. However, in our experience, the acceleration agreements are bespoke. And these sorts of agreements typically include, the acceleration measures that are to be employed, the revised completion date and revised programme, and payment. Acceleration generally comes at a cost to an employer. So if you are an employer and you're considering acceleration, then you need to think about how time critical the works are against the likely costs payable to the contractor for accelerating. From an employer's perspective, The employer may want to protect their position in relation to future claims for extension of time and loss and expense by restricting the contractor's entitlement to these in circumstances when a revised completion date has been agreed. They might also want to think specifically about dealing with COVID, if that is the reason for the acceleration agreement being entered into, and they may also want to revisit the liquidated damages. Not sure, Gavin, if you've got any points from a contractor's perspective.
Just a couple of points to make, Karen, from the contractor perspective. If the contractor has got no entitlement to extension of time under the building contract as drafted, then they may want the acceleration agreement to include a clear extension to the completion date, so that any liability or liquidated damages for the period to the date of the acceleration agreement is excluded. The contractor may also want the acceleration agreement to have provision for COVID-19 specific events that allow claims for extension of time, loss and expense, and increased costs arising out of any future impact of COVID-19 after the acceleration agreement has been entered into.
Right, well, thank you very much both. That brings to a conclusion our fourth and final round in the debate. Thank you both very much for what I regard as a civil and cogent debate, not always a feature of some of the debates I've recently seen on television. So you both get my vote next week. Thank you also to all the delegates for attending the webinar. We've got time, I think, maybe for 2 questions. So I'm going to pick 2. Let me just see. Here's one. I think the first one I'm going to ask is about acceleration agreements. Have you seen circumstances in which an employer has agreed to pay a contractor to accelerate works to make up for COVID-19 delays, even when the contractor is not entitled to an extension of time for COVID-19 delay? There you go. Gavin, maybe one for you?
Yeah, I'd be happy to answer that one, Linda. Probably 2 comments to make there. The first is that some employers have taken the view that, well, regardless of what the niceties of the contract are, and even if the contractor is not strictly entitled to an extension of time, for example, or loss and expense, they've taken the view that actually it wasn't the contractor's fault, and they have agreed to pay for acceleration regardless. The other situation that can arise is that at the time that the contract was entered into, often there's a negotiation between the employer and contractor about the level of the liquidated damages. So if as part of that negotiation, the employer has agreed a level of liquidated damages that doesn't fully cover the employer's losses that it'll incur as a consequence of delay, then there can be a bit of an accounting exercise for the employer to carry out. And it may be that it's worth the employer throwing some money at acceleration if the money they throw at the acceleration is less than the shortfall on the LEDs they'll suffer if the project's delayed. And that varies from project to project.
Okay, thank you. And here's a tricky one, and just testing what you've seen here. Have you ever seen the argument under NEC that either party may, this is in relation to the clause, either party may terminate if the parties have been released under the law from further performance of the whole of the contract? So that's the clause that says either party may terminate if parties have been released under the law from further performance of the whole of the contract. Have you seen any such arguments?
I have not, Karen.
I have not either. Sounds very creative to me.
Okay. Well, that's a nice short answer to that. So I'm going to finish there. Everybody, thank you for joining us. I hope you found it interesting and helpful. We'd be very happy to hear from you individually following the seminar. We'll stay online for a few moments if you want to share any of your own experiences or challenges. And I really do hope that I'll see some of you again in the remaining seminars in this series. Thanks, everybody.
Thank you.
Thank you.